whereas if you sold it yourself before death, your basis is what you paid for it, maybe adding a few other things. But if you paid $100,000 for something that's worth $2 million, you're going to have a bunch of capital gains. If you die owning it, your heirs get a step up in basis, so they get the basis, the value on the date of death as their basis. The requirements to make a valid will vary from state to state. With the Uniform Probate Code, we have a little more uniformity from state to state. If a will was valid in the state in which you made it, then it will be valid in any state you go to. So you can take comfort that if you move to another state, you're okay, but you should have it reviewed to make sure it has accomplished what you think it's going to accomplish. Generally, you must be over 18 years of age, you must be of sound mind, and who among us is of sound mind, and you must possess testamentary capacity. Testamentary capacity in this state is that you know what you possess and you know the natural objects of your bounty, who you would normally leave those things to. If you don't know those things, or if there's some question about whether you know those things, you may not possess testamentary capacity. You may not be able to make a will. For the will to be valid, it must be in writing, it must be signed by you, or you must have directed someone else to sign it in the presence of witnesses. It can be self-proved, which means when a probate is begun, it used to be that you had to bring the witnesses in that were there when the will was signed to say, yeah, I saw him sign the will. Now you can do a self-proving affidavit where a notary comes and notarizes or takes the oath of the testator and the witnesses that they saw the testator sign that will. So that self-proving affidavit eliminates the need to call in witnesses later. Most states, again, allow the testator to attach that memorandum of personal property. Anything that you want to go to a particular person, write it down on that piece of paper, attach it to your will. You want to make sure that any items of personal property are addressed. Very quickly in the midst of this, I just want to address quickly funeral arrangements. Make those up front. Do it yourself. Go pick out what you want, because if you depend on your children to do it, they are going to go spend the very most money they can spend to bury you, and that may not be what you want. If you go, you pick it out, you pay for it, then it's done. Nobody has to worry about it. Nobody has to fight about where you're going to be buried, what you're going to be buried in, what clothes you're going to have, what jewelry is going to be. You have made that decision. So take control and control your own destiny with regard to funeral arrangements and personal property, if nothing else. A revocable living trust, that's regarded as a will substitute. It is done in many jurisdictions for avoiding the expense of probate, and it also eliminates, at least in South Carolina, the ability of creditors to make claims against the property that is in a trust. So what you do is you appoint a trustee, who is generally yourself. You have beneficiaries, which are yourself, and you have remainder beneficiaries, alternate beneficiaries, who get it when you die. So you get the use of it while you're alive. It goes automatically to the people that you designate at your death, and it avoids the need for probate. There are some drawbacks to doing this, and I've seen some beautifully done packages of trust agreements, and not a thing was put in it. So you have to title all your property in the name of the trust. It means you have to do a deed for all that property, and it may be 15 deeds to convey property into that trust. You also have to do anything else that's titled. Boats, airplanes, cars, anything that has a title on it has to be put into that trust. Brokerage accounts, bank accounts. So consider, if there's anything left out, that's going to have to be probated. So you may save considerable expense, but you may not save all the expense you could have saved had you done the funding of the trust. In some states, it's a lot more expensive to administer an estate than it is in South Carolina. In some states, attorney's fees are statutorily set as a percentage. In some states, there are lots of hoops to jump through that make it very expensive. And in some states, living trusts or revocable trusts are much preferred to wills for that reason. Other advantages, privacy, that's not at the courthouse for everybody to see. If you have a will, your will's at the courthouse, a list of everything you own is at the courthouse. Anybody can come in and look at it at any time. If you're doing a trust, you can also include a disability protection piece to your trust, so that if you become incapacitated, there is a trustee who's going to take over. Then you don't have to worry as much about your durable power of attorney and having the appropriate person to do that. It also allows you to kind of consolidate your assets and have asset management plans that contemplate what you want, what your goals are, where you're hoping to go with that. It also gives instant access to property and money after death. If you have something that's titled in your own name, you die having a will, the probate court has to issue letters of administration before anybody can get to that property to liquidate it, to use it for anything. The personal representative cannot even go in a safe deposit box except to retrieve the will. So, in some cases, we want to make sure that we have money immediately available. A trust is the way to do that. It can also create a step up in basis of property passed at death, and it allows the settlor, the person who is contributing the property, to retain those tax advantages such as the homestead exemption that come along with home ownership. There are disadvantages. It requires retitling, and I have spent 2 years now retitling assets into a trust that was created 15 years ago because they never did it until the husband was diagnosed with Alzheimer's and is incompetent to do it now. And believe me, every brokerage company requires something different to make sure that that is retitled in an appropriate way. It is expensive, it is time consuming, it is burdensome, and folks who are elderly, it is nearly impossible. You have to call, you have to punch in numbers, you have to press 1 for this, 2 for that, and folks that are 80 years old aren't going to do that. After acquired property has to be conveyed or titled in the name of the trust. If you buy something after you create the trust, you have to make sure that that is also in the trust. The trust is a contract which requires a higher level of capacity. Not only do you have to know what you have and who you ordinarily leave it to, the objects of your bounty, you have to know the consequences of entering into a trust agreement. This contract, what the consequences are, what the negatives are, what the positives are. Advanced medical directives, and I'm just going to jump through these, have them. Advanced medical directives ensure that you have end-of-life issues addressed at the time that they become important, and you don't have, again, family members out in the hallway fighting over whether you should be kept on a respirator or you should receive tube feeding. Power of attorney, again, the document that appoints another, the agent, to act on behalf of you, and it should be termed durable, because if it is not, it does not have the word durable in it, that means it is only effective as long as you are competent. And most of you are planning for incompetence. So if you don't have that word durable in there, that's a problem. It should provide broad, flexible authority to the agent. And if you don't have trust in that person, maybe the probate court is the appropriate alternative for you. Then you have court oversight. HIPAA is the Health Insurance Portability and Accountability Act that addresses privacy issues and health information. If you have a family member who wants to know how you are in the hospital, they can't tell them. So if you have a power of attorney, include a HIPAA provision in that power of attorney so that person can find out medical information about you. Your power of attorney should be recorded or filed in the county records office where you live and any county records office where you own property. That way the power of attorney, the agent, the attorney in fact, has the authority to convey title to property, which may be what you want. A power of attorney requires, again, great level of trust, and you should consider having an alternate or successor in there if the attorney in fact can't continue to act because of illness or incompetence of their own. Who's going to take over then? And then we refer to state statute for the manner in which the document is signed or executed. In South Carolina, it's the same formality as is required for a will. So we have to have 2 witnesses and a notary. In this state, you have to have 2 witnesses and a notary in order to record it as well. So you have to refer to recording statutes and execution statutes to make sure that you have executed a valid power of attorney. And an attorney who practices in this area in estate planning should know how to draft a durable power of attorney that accomplishes what you want it to accomplish.